Okay, so we're diving right in today. We're looking at suspicious activity reports,
SARS.
SARS, under FDIC regulations. Now, we're assuming you've already got a pretty decent grasp of the basics here.
Right.
So we're not going to spend a ton of time on like the real introductory stuff.
Yeah.
What we really want to do is make sure that you understand the key definitions and the
Yes.
exact circumstances
Yes.
that would require an FDIC-supervised institution to file one of these.
Absolutely. We want to make sure you know exactly when and why you got to file a SAR. So let's jump right into it. Let's start with a term you're going to see everywhere when you're dealing with SARS, and that's FinCEN.
Yeah, FinCEN.
That's it.
So FinCEN is defined as the Financial Crimes Enforcement Network of the Department of the Treasury.
Okay.
So basically, this is the government agency that's going to be receiving these suspicious activity reports.
Makes sense.
They're the central point for collecting all this info.
That's right. And, their role is a lot more than just receiving reports. I mean, they analyze this data, they look at other intelligence to spot trends, connect the dots in financial crimes, and really help law enforcement fight money laundering and other illegal activities. They're really like the nerve center for tracking financial threats.
I like that analogy.
Yeah.
Like the central nervous system of, financial crime.
Exactly.
Okay, so we have a good picture of what FinCEN does.
Yeah. Huh.
Another term that we need to define is institution-affiliated party.
Yes.
That sounds like it could cover a lot of people.
It really does. So the formal definition is any institution-affiliated party, as defined in Sections 3U and 8B5 of the Federal Deposit Insurance Act, 12 U.S.C. 1813U and 1818B5.
Wow.
I know it's a mouthful, but the core idea is it's anyone who's connected to the FDIC-supervised institution in various ways. This includes directors, officers, employees, even agents acting on the institution's behalf. It's a broad definition because potential threats can come from lots of different places within or connected to the institution.
So it's really about anybody who has, significant access
Yes.
authority or, is working with a financial institution in some capacity.
That's right.
Now, could you remind me again who is actually required to file these reports?
Absolutely. That would be the FDIC-supervised institution.
Okay, and just for, one more time, how's that defined?
An FDIC-supervised institution means an entity for which the FDIC is the appropriate federal banking agency. And this is pursuant to Section 3Q of the FDI Act, which is 12 U.S.C. 1813Q.
Okay, so boiling all that down,
Yeah.
this basically means banks and savings associations that are insured by the FDIC.
Exactly. Those are the folks who are legally required to file these SARs under these rules.
Okay, so we've got FDIC-insured banks
Yes.
and savings associations reporting to FinCEN,
Uh-huh.
and the rules look at actions by, this whole range of institution-affiliated parties.
That's right.
Now let's get into the actual situations that trigger the need to file one of these reports.
Okay.
The first category we're going to look at is insider abuse.
Right. So a SAR must be filed whenever the FDIC-supervised institution detects any known or suspected federal criminal violation or a pattern of criminal violations committed or attempted against the institution or involving transactions conducted through the institution.
Okay.
The really important thing here with insider abuse is that the institution believes it was a victim or used to facilitate a crime, and that the institution has a really solid basis for thinking that one of its directors, officers, employees, agents, or other institution-affiliated party was involved in the criminal violation. And this is regardless of how much money was involved.
Regardless of the amount.
Yeah.
That's a really interesting point, that there's no, minimum threshold.
Yeah.
Why do you think they emphasize addressing this potential wrongdoing from within, even at small amounts?
That's a great question. And I think the lack of a monetary threshold for insider abuse really shows how important it is to have trust and integrity within financial institutions. Even if it's a small crime, if it's committed by an insider, it can really damage public confidence in the institution.
Right.
And it could be a sign of bigger problems that haven't been discovered yet. It's really about addressing the fact that trust has been broken as much as it is about the financial loss itself.
Yeah, that makes a lot of sense. So even a small suspected theft by an employee, if there's a good reason to suspect them,
Yes.
then a SAR needs to be filed.
Exactly.
Okay, let's do a quick little pop quiz.
Okay.
What is FinCEN's role again?
So FinCEN, the Financial Crimes Enforcement Network, is the one who receives and analyzes these suspicious activity reports.
Perfect.
Good job.
All right, let's move on to the next situation that would require a SAR.
Okay.
And this is transactions involving a specific amount where a suspect can be identified.
Right. So we're talking about transactions aggregating $5,000 or more where a suspect can be identified.
Okay.
Here, a SAR is required if the institution thinks there's been a federal criminal violation against it or involving its transactions. And the total amount of money or assets involved is $5,000 or more.
Okay, so here the dollar amount does become a factor, unlike with the insider abuse.
Right.
What's the other really important condition?
The institution has to have a solid reason to think that a particular person or group of people might be responsible.
Okay.
And if they know any aliases for the suspect, those also have to be reported along with their real name.
So we've got to have a decent amount of money involved.
Yes.
And a good idea of who might be behind it.
That's right.
And what happens if there's even more money involved, but we don't have a clear suspect?
Then we look at transactions aggregating $25,000 or more, regardless of potential suspects. So in these situations, if the institution suspects a federal crime involving $25,000 or more, and they believe that the institution was either the victim or was used to help commit the crime, a SAR is necessary even if they don't have a good idea of who the suspect might be.
Okay.
This higher threshold basically acknowledges that large transactions, even without a clear suspect, can be signs of organized crime or big-time illegal stuff.
Yeah.
And that FinCEN needs to know about it right away.
So the fact that it's such a large transaction
Yes.
means that a report has to be filed regardless of whether or not we can pinpoint a specific suspect.
Exactly.
Can you remind me one more time the definition of an institution-affiliated party?
Yeah, so an institution-affiliated party is basically any director, officer, employee, agent, or other person connected to the FDIC-supervised institution.
Okay.
And that's defined in those specific sections of the Federal Deposit Insurance Act that we talked about earlier.
Right.
A lot of legalese, I know.
Yeah. Now, the last category that we're going to talk about involves potential money laundering or violations of the Bank Secrecy Act. And this also has that $5,000 threshold.
Yes, that's right. So this category covers transactions of $5,000 or more that involve potential money laundering or violations of the Bank Secrecy Act. And it's really important to understand what they mean by transaction in this case.
Yeah, because the regulation gives a really broad definition of what a transaction is.
It does. So a transaction in this context means a deposit, a withdrawal, a transfer between accounts, exchanging currency, loans, extensions of credit, buying or selling stocks, bonds, certificates of deposit, or other monetary instruments or investments, or any other payment, transfer, or delivery by, through, or to a financial institution, no matter how it's done.
So pretty much any way that money or financial stuff
Yes.
can move around.
Exactly. It's meant to be very broad and cover pretty much everything.
So within this category, what are the specific things that would make a financial institution think, okay, we need to file a SAR?
All right, so there are three main things. The first is if the transaction uses money that came from illegal activities, or if the purpose of the transaction is to hide where the money came from as part of a plan to break a federal law or regulation, or to avoid having to report the transaction under federal law.
So if they even suspect that the money might be dirty,
Yeah.
or that the transaction is trying to disguise its origin,
Right.
that's a huge red flag.
Absolutely. And the second condition is if the transaction is specifically designed to get around the rules of the Bank Secrecy Act.
Okay, so like breaking up a large deposit into a bunch of smaller ones to avoid triggering those currency transaction reports.
Exactly. And then the third thing is all about the nature of the transaction itself. So basically, if the transaction seems to have no legitimate business purpose, or if it's not something that you would normally expect that particular customer to do,
Right.
and the institution can't find a reasonable explanation for it after looking at all the facts, then it's considered suspicious.
So they really need to understand their customers' normal financial activities.
And anything that seems out of the ordinary or doesn't make sense needs to be looked at very carefully.
That's exactly right. It requires financial institutions to use their professional judgment and do their due diligence.
Okay, so that's a lot of information.
It is.
Let's do one more quick review of those different dollar thresholds that we talked about.
All right.
So when a suspect can be identified, what's the trigger amount for a SAR?
Not including insider abuse.
Not including insider abuse.
That would be $5,000 or more.
$5,000 or more. And if a suspect cannot be identified,
Then it goes up to $25,000 or more.
perfect. Okay, last question.
All right.
What's the definition of a transaction? Again, specifically when we're dealing with potential money laundering or Bank Secrecy Act violations. Okay, so in those cases, a transaction is any deposit, withdrawal, transfer between accounts, exchange of currency, loan, extension of credit, buying or selling stocks, bonds, certificates of deposit, or any other kind of monetary instrument or investment, or any other payment, transfer, or delivery by, through, or to a financial institution. And again, it doesn't matter how it's done.
All right, so we've covered FinCEN.
Yes.
We talked about the institution-affiliated party and the FDIC supervised institution.
Right.
And we went through the four main situations that require a SAR.
That's right. We covered insider abuse, transactions with identified suspects, big transactions without identified suspects, and transactions that might be money laundering or violations of the Bank Secrecy Act.
Knowing these definitions and really understanding those situations is so important
Absolutely.
for keeping our financial system safe and trustworthy.
It really is.
It's a constant challenge for financial institutions to make sure that they're helping people with legitimate financial needs,
Right.
while also being on the lookout for potential criminal activity.
Yes.
Think about the sheer volume of transactions that these institutions process every day.
It's mind-boggling.
It's incredible.
Yeah.
And then you have to be able to figure out what's a genuine financial need and what might actually be something much more nefarious.
Tough job.
These regulations really provide a crucial framework for doing that.
They do. And understanding the specific triggers and definitions that we've discussed today is a fundamental step in keeping the financial system safe. It makes you think about the vast scale of potential illegal activity out there and the really important role that these technical regulations play in stopping it.
It really makes you think.
It does.